Go into John P. Salmond here, Salmond on Jurisprudence, Sir John Salmond. Originally, the first edition was published back in 1902. I have the 12th edition open in front of me that was published in 1966. I'm going to go back to a section and talk about the uses and purposes of incorporations as we continue. Today, I think it's part 6 in trusts. I've shared this briefly with you before. We'll just start with it this morning. We have considered the general use and purpose of incorporation. By the way, this is not an inconsequential book. If you study law, you're likely to have read this book or had it assigned, or at least in your reading list. We have considered the general use and purpose of incorporation. Among its various special purposes, there is one which has assumed very great importance in modern times, and which is not without theoretical interest. Incorporation is used to enable traders to trade with limited liability. Limited liability. We always talk about responsibility, 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 but somehow the conversation never really does get around to accountability, either in words or deeds. And why is that? Well, because incorporation is used to enable the traders, I guess you could say traitors, the treasonous traitorous, treacherous hooers, traders to trade with limited liability. As the law stands, he who ventures to trade in propria persona, I'll say that again. As the law stands, he who ventures to trade in propria persona must put his whole fortune into his business. He must stake, in other words, he's doing it in his own person. He must stake all that he has upon the success of his undertaking and must answer for all losses to the last farthing of his possession. Remember, in the old days, in the good old days, we would have a public slave, also known as a public servant, and we would, either elect them or hire them. But they would have to take an oath of office, and then they would have to post a bond, and it was to the last farthing of their possessions. They must answer for all losses, remember? We don't do that anymore. The risk is a serious one, even for him whose business is all his own. But it is far more serious for those who went into partnership with others. In such a case, a man may be called upon to answer with his whole fortune for the acts or the defaults of those with whom he is disastrously associated. Wow. Amazing. Novel concept. I wonder what the sun god, Lord Brown, would have had to say about his misdealings with British Petroleum. How about Tony Hayward? Had he had to put every sou and farthing on the line for his decisions, as regards Macondo, gently weeping. In such a case, a man may be called upon to answer with his whole fortune for the acts or the defaults of those with whom he is disastrously associated. It is not surprising, therefore, that the modern commerce has seized eagerly upon a plan for eliminating this risk of ruin. Incorporation has proved admirably adapted to this end. They who wish to trade with safety need no longer be so rash as to act in propria persona, for they may act merely as the irresponsible agents of a legal entity. The irresponsible agents of a legal entity. Yeah, Lloyd Blankfein Timberlake was a shitty deal. But if you would have had to put your billions on the line, maybe your agents would have sold those shitty Timberlake deals. It's not my words, they're his words in a Senate hearing. If the business is successful, the gains made by the company will be held on behalf of the shareholders. If unsuccessful, the losses must be borne by the company itself. For the debts of a corporation are not the debts of its members. And then it goes on and it has a lengthy Latin quote, which I'm incapable of rendering. The only risk run by its members is that of the loss of the capital with which they have supplied or undertaken to supply the company for the purposes of enabling it to carry on its business. To this, to the capital so paid or promised, The creditors of the insolvent corporation have the first claim, but the liability of the shareholder extends no further. Just a little basic understanding in law. Not that I'm any lawyer. It's kind of an amateur jurisprudent. I love to study and read the things of law and philosophy and history. The Burgeoning Trusts. Back to our textbook here, college level. Devine, Breen, Frederickson, Williams, America Past and Present. This would be like a U.S. history text. Certainly far more advanced and lengthy than you could cover in a high school class. The Burgeoning Trusts, page 660 here. The Burgeoning Trusts, as businesses like Ford, that's Ford Motor Company, as Fords grew, capital and organization became increasingly important, and the result was the formation of a growing number of trusts. He talks about that with Gustavus Meyer's book as well. Standard Oil started the trend. Do we need to say that twice? Rockefeller Trusts. Standard Oil started the trend in 1882, but the greatest momentum came 2 decades later. Between 1898 and 1903, a series of mergers and consolidations swept the economy. Many smaller firms disappeared, swallowed up in giant corporations. By 1904, large-scale combinations of one form or another controlled nearly 2/5 of the capital in manufacturing in the country. And think not there wasn't plenty of white slavery going on at this time, you know, the little boys used as chimney sweeps. Yeah, and worse. The result was not monopoly, but oligopoly. Control of a commodity or a service by a small number of large, powerful companies.